We are radioactive.
All right. I am sitting here with Paul Hurd. Paul Hurd is an attorney here in Monroe, Louisiana. He's the owner of Home Title Guarantee. I've known Paul a pretty good while now. He's done some real estate closings for us. He's helped us on some real estate deals where we needed some kind of advanced legal support. And so Paul has been our attorney in a number of different ways. Paul's been a lawyer here in Louisiana for 40 years now and been doing real estate title work for 30 plus of that, the majority of it. So what I'm going to do over the next several videos, I don't know if this is going to be 3 or 4 or turn into 16 like the last series we did, but just asking about some specific legal issues as it relates to real estate. And an expert like Paul is going to be able to give us some good information. Now, and as you know, we're not giving legal advice here. Paul's a real sharp attorney, but he's not advising you in your situation. You're going to need to talk to your own attorney as it relates to your own deal in your own state. But what we're going to do here is probably just give you some general information that may help you go, oh heck, or aha, or dang, I need to look at that or think about that as you get involved in your next real estate deal. So what we're going to talk about today is access, legal access, deeded access. We use a number of different terms. Here in Louisiana, our official word is servitude. Where you are in another state, you're probably going to be familiar with the word easement. If you hear them back and forth, they're basically interchangeable, at least for our conversation today. So don't let the language throw you off. Paul will be speaking mostly from a Louisiana point of view, but a lot of this stuff will be very similar, if not the same in other states. But don't take that to the bank. Again, talk to your own attorney, get your own specific information about your specific situation. So I'm going to go ahead and get started on this. I'm going to ask Paul to tell us, Paul, what makes an access legal in terms of real estate deals, like we throw those terms around. What's a legal access?
Well, what we're talking about is you may not think about it, but when you buy real estate, you're really checking 2 things. First, you want to own the piece of dirt that we're talking about. The other half of the title search is, do you have access from that piece of dirt to a public road? And if you do have access, what type of access? How is it limited? Does it meet your need on the use? Because like any choke point, you could have a great piece of dirt and not be able to use it the way you want to because your access is not adequate to use it. So when we're talking about legal access, we're talking about different ways that you can establish the legal right to not own the access area, the right-of-way area, but how you own one piece of land and you have the right to go across somebody else's land to get to the public road and back to your land.
Yeah, I get it. Paul, I talk to clients constantly in our business, and I've heard this so many times. I can't even count the number of times. Well, here in Louisiana, you can't deny somebody access to their property. And they say that as a way of saying or deflecting when I've brought up, hey, your property doesn't have a legal deeded access, so that's an issue. They look at it a lot of times as a non-issue because you can't deny access in Louisiana. And I understand what they mean by that. They're saying that, typically you can get access to a landlocked tract, but I'm quick to tell them in my simple way, hey, just because it's so doesn't mean that guy you're going to cross is just going to bend over and allow that. There's going to have to be a mechanism triggered to make that something that we can hang our hat on and call a deeded access. Can you speak to that?
Yeah, and let's say this. The concept is, I think in most states, is land that is landlocked in the sense that you can't get to it from a public road is not very valuable. And public policy says we want the real estate in our state to be valuable. And so the law says you can always go out and buy an access. But the question is, if I can't buy it from somebody, if I can't, with enough money and enough persuasion, get them to give me access, then you're talking about, what do we do if I really am enclosed? And that's an enclosed estate is what we call it. Mm-hmm. That means, by definition, you don't have a legally enforceable right-of-way or an easement or servitude that'll get you from a public road to back and forth to your land. And that's what we call an enclosed estate when you don't have that. Now the question is, how do you get it? Mm-hmm. And you can either go negotiate it, or the law will let you, under most circumstances, demand that access out from your enclosed estate. You can even buy the estate knowing it's enclosed, and it doesn't. You don't have to allege, oh, I didn't know it was enclosed. Doesn't matter. But once you buy it, it does matter how it became enclosed, because there's a couple of exceptions on the ability to demand an access under law, and it has to do with how you became landlocked, if you will, or enclosed.
Yeah, I actually wrote that down. That I don't know everything about servitudes in Louisiana, but I've learned a lot. I've always said I'm not an attorney, but have to pretend to be one sometimes. So it seems to me that there, in my mind, one glaring exception to you can always get legal access, and it's a way that a property was enclosed. Can you? What's the biggest way really, that it's?
Here's how enclosed works. If you're really enclosed, you have the right from your land to access the closest public road. Now, what that means is you're going out of your property, and that's how the law decides which one of your neighbors must let you through. The law says in Louisiana, the way to get to access is the neighbor that's going to have to let you through is the one who is between you and the closest public road. Now, the way you lose the right to sue him is, let's say you bought your land, well, you had 80 acres, you kept 40 and sold 40 off, and that 40 had access. All right, but now your 40 that you've kept has the closest road is actually out another neighbor across his land, and not how your land used to get there. If your 80 acres could get to the road, when it was 80 acres, it wasn't enclosed. If you cause yourself to be enclosed, you can't go to your neighbor who's only 50 feet from a road and say, oh, you have to let me across there, if you had access across the other 40 that you just sold. And that's how the primary exception that you know of is the one that does say, if you created the enclosure, you can't go to a neighbor and tell that neighbor to give you access.
Yeah. I'm glad you said it that way. You said it, you used the exact phrase that I've used to explain it to people. Hey, if you cut yourself off, is how I say it.
Exactly
if
right.
you enclose yourself, if you did it, then you've lost all of your the rights that the code allows us for access.
Against neighbor. No, there's one other access that's available, and that is the guy you sold to may be obligated, or he may not know it, but it's what we call, there is already a right of access by destination. A weird phrase, but what it really means is if I had 80 acres and I sold the front 40, and prior to selling, that 80 acres was accessed by a public road just on the other side of the let's say the southern 40, you kept the northern 40, you sold the lower 40, and you used to go out the part you sold. You have, by operation of law, a right of access by destination across the 40 that you just sold. And it's called right of access by destination. And what happens is, if that's how you access the public road before you sold, the person who buys it has to give you that right for free. Okay. And so you're not locked out. And that is that even if the person you sold to, we've got the public records doctrine. And what that really means is when I buy land, whatever I see on the public record is all that binds me. Even if the person you sold that 40 acres that you're going to later have to come across, even if he sells it to a third party under the public records doctrine, that piece of property is the one that's going to have to grant you access, not the neighbor who may be closer to the road. Remember this, it's a two-stage process. The first thing, when you're landlocked one way or the other, the law has to designate which piece of property is the one that's going to have to take this burden, because the law's decided we don't want property landlocked. It just becomes worthless, or the owners become, it becomes worthless because the owner can't make any economic use for it. So the first thing we do is decide, is the person that has to give you access, in quotes, the neighbor that is closest between you and a public road, or is it a successor of a piece of property that a common owner sold off? And you don't even know that till you run the title. Yeah. And because if I was the neighbor that's only 50 feet from the road and you're behind me and you say, need to come through your front yard to get to the road, first thing my lawyer's going to do is run title on your property and see how did you get landlocked. If you got landlocked because you used to be the 40 and the 40 and you used to go out to the south and now you want to come across mine to the east, nope, you don't get to, because your rights are against the person who used to be one of your tracts.
That makes sense.
I mean, that's how they decide first which piece of property we're going to go across. Yeah. Then you start talking about where it has to go.
Got it. If I've had to get access, for a number of properties, a number of different ways, and you're familiar with some of it over the years. You've exhausted every means. You've talked to every person. You've written every letter. You've offered
exhausted any contractual ability to buy it.
Yeah, or you've gone and you've said you've tried to negotiate access through every feasible every means necessary, and then it comes time to just, hey, I'm going to obviously have to sue for access, which we've had to do before, and so I've got a little experience with that. One time it was extremely simple, bang, bang, bang. Another time it drug out and drug out and drug out. And another time you're familiar with. So, typical scenario, if somebody has to sue for access in Louisiana, what are the steps? What's the process?
Well, the first thing, all right, so we've got the enclosed estate. The first thing they need to do is run title, figure out how they got enclosed. Okay. Because that's going to tell them, do I sue the neighbor who's got the shortest distance to a public road, or do I have to sue a predecessor that we were common owners, where the owner, my predecessor on mine, accidentally sold his access off. What it makes him do is go back and get it from that person. You decide you determine legally which way you think you have to go. Typically, you end up having to go the shortest route. Mm-hmm. Okay. All right. And when that happens, then you contact those people and you have to sue them and just say, look, you've got to give me access across your property, and if you can't negotiate a price, then you sue them, and the judge is going to tell them if they meet that criteria that they're going to have to let you across. Now, it doesn't mean they have to let you across for free. Mm-hmm. They have to pay, they being the enclosed tract, the owner of that, if you want to cross, you have to pay three things. You got to pay what the going price would be for that access, that servitude. All right, you've got to pay. Now think about it. I've got a home, and I got a 5,000 square foot heated home, and your access is going to have to go through my backyard. Well, the cost of the dirt, the cost of the land that will be burdened by that is one price. The damage that putting a busy street, depending on what you're doing with your land, through my backyard of a very nice piece of property is damage also. You have to pay for the access. You have to pay the damage that you do to the value of my property because the law says you're going to get to put that road there. And then you have to pay for the actual, all the construction of your own access. So, but you can have real damages. I had one that we fought for 6 or 8 years, and we had exactly that problem where the public road ended. It wasn't like we had one traversing. We had a public road that came up and ended, and that was the closest road. And right between the end of the road and the enclosed estate was the front yard of a very nice house. Next to it was another home of the daughter, and south of it was another home of another daughter. So you had this family perfectly set up, and they were going to have to come through there to get to the enclosed estate. And they paid for the right-of-way. They paid for the damage to the property.
Wow. I'm not.
And then they had to tear down the trees, do the land work, and build the right-of-way.
Wow. I'm not used to doing, when you brought up, homes and things like that, the access that I have to deal with, and my business is, rural by nature, and usually you have, timber that has to be replaced, things like that. But devaluing a 5,000 square foot home, I haven't had to deal with that.
No.
Let me ask you this. Why, and the reason I'm asking this is I learned this from you in the very first closing that we ever did. You probably won't remember it, but why is it important that a servitude that serves a piece of property here, why is it important that servitude be assigned, to use that word, for the entire tract, as opposed to just, because a lot of times I've had to describe servitudes that'll go to a point on a line at a corner or something like that, and and it may be 200 plus acres. You taught me a lesson in here one time on a closing that since then I've changed the way I look at it and think, and I make sure that any servitude that we get is to the benefit of the entire tract. Explain why that's important.
Because servitudes in Louisiana particularly are defined this way. It is a right to cross from one point to another across one person's land. We call that the servient estate because it serves, it's burdened. You cross the servient estate to benefit a dominant estate, i.e. the estate that is granted the right to come across. These are rights as between tracts of land, not people. And so what it means is if you get a servitude of access but don't define the extent of the dominant estate, let's say you had 160 acres, you're buying 40 in the right-of-way, and you now got 200 acres. That servitude that you buy when you buy that 40 acres better identify 200 acres, or it can only be used to access whatever dominant estate is identified. And the reason this really matters is what you find more and more. I deal as much with as rural land becomes urban or residential. It starts getting chopped up out of 40s into 5s and 10s and 20s. Well, someone will grant you a right to get to your home. If I've got 10 acres behind my neighbor, he'll give me an access across his property to get to my 10-acre home. But will he give me access that can come from my 10 acres, and can I let the people behind me that own 200 acres use that servitude? If they get to me, can they then use his? And the answer is no. He grants that servitude for a particular smaller dominant estate, or if you're the guy in front who doesn't want a lawsuit, the guy who needs access is the guy behind you, you can grant it for the benefit of the 10 acres behind me. People behind him can't use his access to get to the road. particularly out of convenience. Remember, once you grant it, what if the guy behind you is the one they're going to pay? You've already granted the right of access. If you're the front guy, the last thing you want to do is to create a road. You didn't mind one house coming through almost like a double driveway versus 35 homes behind me, all coming through right by my house because I granted the guy behind me the servitude, and then he granted it to 100 acres behind him. So anyway, it's important, regardless of which side you're on, to make darn sure that you know, regardless of which side you're on, who the dominant estate is, how big it is, or how big it isn't. And so anyway, that's a very important problem.
You know, as you know, we've with partners that I represent, investor groups, we buy large tracts of land and divide them up. The particular tract that I used as an example for that question was originally 2,180 acres, and we had a closing in here for 200 of it, and it had multiple access points all through it. But one thing I've done since that closing was making sure that any servitude we got, just the entire tract we were buying was described as the dominant estate, so that this servitude would serve it no matter how we chose to divide it.
However you divide it.
Exactly. So that was a good. The closing went good. It wasn't an issue, but I remembered that lesson because it could have been an issue.
And the other thing I run into is all right. You run into that, and now the guy in the front says, 200 acres could turn into too much traffic. I'll let you subdivide your land up to 4 tracts or 10 tracts. I did one just outside a subdivision where, and what you'll find in subdivisions is a subdivision, if because of the topography, they otherwise want to put their road on the outside of their 40 acres, let's say, and put the houses on the inside. It just depends what's uphill and downhill and where the drainage is. But let's say they want to put them, it turns out that you want to put the road on the edge of the property line and the homes being divided happen to be on the inside. What you do is you put your road 1 foot on the inside of your property line. Now your neighbor can't access your road. If you take that road and you put it in and then you dedicate it as a public road and it's against your property line, then it's also against your neighbor's property line. And by doing that, he gets free use of the public road. What we did was we put it 1 foot away from the property line, and we agreed with the people next door to us that they had to pay $10,000 for every house they wanted to access our road, and it was to sell them the right to come across 1 foot of land. But what it really did is it made them share in the cost of developing that road. If you're going to use it, you're going to get economic benefit of your land because of our road and not have to put your own in. It was a way to, a landowner could recoup the cost of that road. He could afford the whole subdivision partly because he was sharing the cost of his road with his neighbor.
Answer this in the context of primarily rural real estate, timberland, honeyland farms, ranches, not Deborah Drive in Monroe. Answer this one in that context, rural land. Do you recommend that servitudes always be surveyed?
Well, always is always a strong word, but always, I'm going to say this, out where even when you're out in the woods, the one other risk that we've really got is while you are buying 200 acres, in the city, 6 inches matter. Out in the woods, 6 inches, if that fence was put where it belonged, maybe it doesn't matter. But what's going to happen out there is the sooner you survey, even if you're just surveying the servitude, you're talking about surveying an area that's outside of what you're buying, but the sooner you get it surveyed, the more you're going to know about any discrepancies in exactly of where you think the property line is versus where it is surveyed out to the inch where it really is. And that's valuable to you because just because there's a road out there and they're going to give you a servitude to use that road, you don't know whether the people that you're getting it from really own that road or whether it meanders across a line and comes back. Everything is for clarity. And so if you're investing big enough money that you're going to spend it for 200 acres, a survey that's going to cost $8,000 to me is a heck of an insurance policy to make sure I can get to my 200 acres.
Yeah.
And so I'm not saying it's necessary, but you're going to do it sooner or later. Why do it when you have no leverage versus let's get this rascal done so that we know that we've got the leverage that if there's a problem, you can reduce your purchase price by $8,000 because you suddenly find the guy who's selling you the 200 acres doesn't have as good a access as you thought he did. The other thing that I've run into with these accesses that surveys help is you'll see if someone sells a 40-acre tract and they get a right-of-way to public access to the road along the western 30 feet, 40 feet of the tract below. So what you've got is from yours a parallel line that's 40 foot wide from yours to the road. And it looks great on a map until you go out there and you see that there's a 12-foot slough that cuts dead across what you've got. Yeah. And while you've got legal access, it's unusable. So the survey also will help you confirm, or certainly if you're buying and someone's just giving it to you, don't be foolish enough not to mechanically walk the property and make sure that the servitude that you have is functionally usable.
The phrase you said looks good on a map. It's been in the last year we sold about 190 acres and a large timber company. I won't name who it is, but we know who it is. Granted the servitude from highway about a mile through their timberland to this tract, and it's normal course of business for them. And of course, I went out there and looking at the property and tearing it all apart. I saw that the servitude, the road, gravel road, it like you said, it meandered
off the line
just a few feet, just to go around the head of a big hollow. And in doing that, it crossed into the school board section just a few feet, section 16 of this township range. And so the servitude they were granting this timber company for a mile, there was, 100 feet of it that dipped in to the school board section. And it was all on the map that they had granted it like that. I'm going, God, you can't grant it. You can't do this. This isn't yours to grant.
Well, at least what they showed that they had to go outside their section versus when it comes right down, and then when you actually look, you've got the hollow and your actual access that you're seeing on the ground looks fine, and you compare it to the map, and there's a part there where it swings a little right, and then you don't realize, wait a minute, I'm going too far right, I'm into section 16.
Exactly. But the deal still happened because the buyer was a cash buyer, and and the road had been there a long time. It's not going to be an issue. They'll never say anything. But technically, they were granting a servitude across property that wasn't, or piece of it that wasn't theirs.
I'll even give him another bit of information. You can't prescribe against government.
I didn't even know that piece, but he was thinking, hey, this road's been here since forever.
You can buy it, and the school board, as governmental entities go, they're often as reasonable as any. I mean, there are people that are reasonable people trying to get along, trying to educate the kids, versus you run into the U.S. Forestry Service. You may not even be able to figure out who to talk to. And one day they say, get off my land. Now what do you got? I mean, that's I've got that in the office right now, is that we've got someone that needs to get a servitude. The road's not on the section line. It's 100 feet or 200 feet inside a section owned by the U.S. Forestry Service on both sides. And these people have been accessing their little tract of land for a long time, but you can't prescribe against government.
So I did not know that.
And so you run
point.
into a problem of now we've got to find someone high enough up the ladder in authority that will, they'll tell you unofficially you can come and go. They don't care. They're very accommodating unofficially. Go get a bank loan on that house,
Right.
that acreage, that 10 acres, with no legal access, and you can't do it.
Yeah, you're not going to be able to write a title policy on that.
Right.
Last question for you, Paul, and it's a big, broad one. So pick your best piece and throw it out there. All your experience with real estate, all the deals you've seen come and go, and all of thousands of deals. What's your best or biggest or what thing top of mind piece of advice to a buyer regarding access as it relates to what we do with rural land? What would you tell them? If you tell everybody I do business with as a buyer, what's your best piece of advice?
Think about when you're getting in and when you're going to get out. Are you going to buy it and use it for timber for a while and then try to cut it up? Are you going to keep it for a while? But here's what I tell them about access. Don't just get good enough access for today's use unless you're getting in, you're going to clear the timber, cut it up a little bit and sell it and go. Think about, and I had one that somebody was going to get 10 acres. And I said, well, what about a 30-foot right of servitude? They said, look, 30 is okay, but you can't, someone told me, you can't get the electric people to run your utility unless it's 60 feet wide. Well, I hate to say it. I didn't know that was a requirement to get the electricity in there. But the point is that if you're going to keep it, make sure that you got enough that you can do a two-way road in and out simultaneously. If I'd have taken 30, my piece was destined to have been the end of the line. It wouldn't be developable because you couldn't. We'd ultimately get the electricity in there, but you're still going to have a little narrow entrance and exit. My answer is you buy good land with lots of ideas. Make sure you equate that to what do I need now for my access, that it's big enough for my project now and later too.
All right. Well, listen, hey, appreciate you watching and listening. Some of you are listening to the podcast. Some of you are watching video. Again, talk to your own lawyer in your own state. If you want some information about Paul's services here in Northeast Louisiana, he's in Monroe. His information will be down in the comment section, and feel free to reach out to him. I use him personally, so I recommend him. So appreciate you watching and listening. Thank you, Paul.
Thank you. Enjoyed it.